Hi, Judge Binkley. How are you?
Well, how are you doing?
Doing great. We've got 26 people on the call, so if you are ready, we are ready.
I am, and I'm sorry. I just completed an order of protection hearing and had to do some last-minute statements to the respondent to make sure he understood what he was supposed to do and not do during this period of time. So it took a little while then to do all that. So sorry, I'm late starting.
No, thank you so much for joining us and making time for the Nashville Bar Association. We understand that the work of the court comes first. So with that, we will begin our town hall with Judge Joe Binkley Jr., who presides over the Fifth Circuit Court in Davidson County, and is also the presiding judge for our trial courts. Judge Binkley, welcome. Thank you so much for being with us.
Pleasure. Glad to help.
We're hosting these town halls to give our members an opportunity to ask questions and to hear from you about the different procedures and changes that we've all been experiencing over the last 6 or so weeks since the COVID-19 pandemic became our reality. So I'd like to open up by just asking you generally, what have you seen in terms of changes with procedures and how are those working out in your court?
All right. Well, I'll start with what we're doing in the Fifth Circuit Court, and I can tell you what all the other circuit courts are doing that do the same thing I do. That's First, Second, Sixth, and Eighth, in addition to Fifth, which is where I preside, Fifth Circuit. So what we've been doing, we're hearing all Friday motions. We're not doing them all on Friday because they are taking longer, and understandably so, when we're doing them by telephone. And they're working out very well, I'll have to say. I think everybody is pleased with how it's going. It does take longer, but it's okay. Longer is better if everybody is getting to have their say. And I'm getting to ask questions and, do the same things that we would do if I were in the courtroom and the lawyers were in the courtroom. But we just don't have the benefit of face-to-face discussions, which does help. We don't have the benefit of using the Elmo and the other devices that allow us to put documents on the screen for everyone to view. And so everybody has to be well prepared for documents that need to be discussed, case law, and sometimes I don't have the case law that I need, so we have to take time to print it and let me read it, and then I try to decide. Well, when I say try, I mean like 99% of the time. I'm going to give a verbal ruling on the motions, and I may have to put everybody on hold for a while I review things that I think I need to review in order to make a sound decision. But I think there's a big premium. I always have thought this and continue to think this, there's a big premium on getting the decision made that day rather than taking matters under advisement. Now, I did take one matter under advisement, a healthcare liability case, a couple of weeks ago, because we have no case law on the issue. So it's going to be a case of first impression, and it'll go up, and I'm going to allow a discretionary appeal. So it can go up and be decided, hopefully, before the merits of the case are ready for decision by a jury. So, and I'm not doing all of these on Fridays. I'm trying to get prepared for them as I move along in the week. And of course, and some of the lawyers may not really know how this works. I didn't know how it worked until I became judge at the Fifth Circuit Court in 2008. But the responses to motions don't have to be filed until the end of business on the Monday before the Friday. So the clerk's office doesn't get all that together for the judges to to review or start reviewing until about 10 or 10:30 on Tuesday morning before the Friday docket. So and for instance, this week we have many really more than the norm contested motions, and so we're going to try to take as many as we can today. And we'll try to do several today that don't require a lot of some preparation, but not intense preparation. And then start working on some on Wednesday and some on Thursday, and then if we have to, we'll do some on Friday. But this is an unusual week. We've been having more unusual weeks because of this pandemic. I think people have more time to devote to their motions and to their briefs, and it's fine. And so that I think we're getting more paper to review, but that's okay. More is better a lot of times, because particularly more case law, the more statutory issues that I can have briefed, the quicker I can make a decision. Easier for me to make a decision, and the quicker I can make the decision. So that's what we're doing with motions, and we, of course, following the Supreme Court's order on, as we all are, all the circuit courts are. We're not doing any in-court proceedings for non-jury trials or jury trials. We're not subpoenaing people for jury duty yet. There will be a call this afternoon with Chief Justice Bivens and as many trial judges as can be on the call. If they can take up to and more than 200 trial judges on that call, and that'll be 2:00 this afternoon, and we'll learn a little bit more. I'm thinking what's going to happen based on the conversations I've had, that we're going to try to start doing some non-jury trials and just keeping people at the proper distance. And we can do that real easily. I think all of us can do that. And for instance, today on this order of protection, which is an emergency hearing, one of the few emergencies that allows in-court proceeding, the one that I had today, I'm having the witnesses not sit in the witness box next to me. It's too close. I'm having them sit in the jury box in the seat nearest to me on the front row with a handheld microphone. And I think that's what we'll do if we can start doing non-jury cases. And I think the suggestion has been, and this is not in stone yet, but the suggestion has been that we have witnesses either wait in their cars if that's the thing to do, or wait in proper distances from each other in the hallway. We've set up on the 5th floor the benches far apart. We got chairs that are far apart. So we're going to try to keep people away from each other, but try to gradually get back into it and start trying at least non-jury cases, and hopefully start the jury trials soon. But with the jury trials, of course, we have to have jurors, and I think a lot of folks don't know this, and I didn't know this either until I started this job in 2008. But in order to get jurors to report for a particular jury week, we have to send the subpoenas out no less than 6 weeks before that week, preferably 8 weeks before that week, that they're subpoenaed to appear and be prospective jurors. And I think, right now there's most people are very deathly afraid of getting together, particularly in a jury assembly room where people are packed in there, 180, 190 people side by side. It's just not going to work until things get a little better. And unless we can do some innovative things. And I know the criminal courts, I think Judge Dalton had a meeting. Is that right? Was it yesterday? Or?
Yes, we talked to her yesterday.
Okay. And I know the criminal court judges are very anxious to get back to having grand jury proceedings because they can't move any cases forward without an indictment. So there's been some discussion about maybe conducting grand jury proceedings in the jury assembly room in the Birch building, where the prospective jurors for grand jury can be far apart from each other, and that may work. I think it. I don't know whether Judge Dalton talked about that or not. Do you recall?
No, she didn't talk about that. She did talk about the large decrease in volume of people who have been going through the AA Birch building. But one question I asked her, and I have wanted to ask you as well, is what do you anticipate the Tennessee Supreme Court is going to do as we get closer and closer to April 30th and the expiration of their latest order?
Well, I'm thinking they're going to, based on the discussion, we're going to try to start doing non-juries in May. And I'm thinking maybe no juries in May, no jury trials in May, and maybe no jury trials in June. That's my guess. We only and civil only has 1 week in June anyway. Criminal has 3 weeks, and they're of course very anxious to get things moving for them. But you know, we've still got the problem of all these people that are subpoenaed for jury duty. Going to be sitting very close to each other in a jury assembly room, and I don't know. It's just, it's up in the air, really.
What do you anticipate in terms of hearings? Will we continue to do them by video and telephone call, or do you think that we'll start to have some in-person hearings?
Well, it might be easier to have in-person motion hearings if we keep people separated, but if you have a lot of motions on the docket, you've got a lot of lawyers, and either you've got to be sitting very far apart in the courtroom, which might not be possible with that many lawyers, or have some in the courtroom and some outside the courtroom, or stagger the hearing times, which is what I do anyway, particularly if I've got some intense motions for summary judgment, motions to dismiss and face that claim. They a lot of times take longer, and I have people come later. So I think we can do that. I think we can start having in-court proceedings with motion hearings and with non-jury trials. We just keep people separated in the process of waiting to have your case heard on a motion docket, or waiting to testify if you're a witness on a non-jury case. So I think we can start doing that fairly soon. That's what I think.
How have you been handling depositions for cases that are pending in your court, and how do you foresee those happening going forward?
Well, in order to keep things moving, I've just ordered one. In fact, I think you were involved in it. Depositions to occur by video, and not wait until you can have a face-to-face deposition, question and answer. I think if we need, in order to keep things moving, we just have to do it that way. It's maybe not preferable. It's not the best, but we're not in the best of times, so we have to adapt. And the best way to adapt is do it by video conferencing, and I think you can accomplish almost the same thing. I mean, your image is very, very good on this laptop, and I think that can happen very easily with witnesses and parties who have to have their depositions taken. And I believe the other circuit judges are going to do the same. We're all doing pretty much the same now. The Sixth Circuit, y'all may know, Judge Brothers, he's doing he calls it the federal model, deciding cases on the briefs and not having argument unless he is convinced that by the lawyers talking to him about it, that they really need to have oral argument. Then if that's the case, he'll conduct them by telephone or video audio conferencing. But he has to be convinced that it's going to make a difference. Now, which means do your best, make your best shot, Judge Brothers, if you want to have a hearing by telephone or video on a motion. Now, we are doing telephonic settlements, minor settlements if they are $10,000 or greater. The statute says that it should be conducted in chambers, which of course we can't do in person in chambers, but that's one of the Supreme Court rules that we now can do those by telephone or video, even if it involves $10,000 or greater. So we're all doing those by video or telephone. And I'm doing mine by telephone. I'm asking lawyers, and I think other judges are doing the same thing, to submit their documents, their petitions, and their orders ahead of time, so we can review them and then not spend so much time on the phone with the parties or the lawyers. And the First Circuit Court on motions, Judge Gaydon is doing summary judgments and motions dismissed or failure to state claim. He will do those by telephone or video. The others he prefers to do on the briefs. Now, you may be able to convince Judge Gaydon a little easier than you can convince Judge Brothers to hear other motions other than summary judgment and motions dismissed or failure to state a claim by telephone or video. He can be more easily convinced, I think, but you got to convince him that oral argument is preferred on motions other than summary judgments and motion to dismiss or failure to state a claim. Second Circuit, I think, she's doing a bridge phone for all of her civil motions, but she's having everybody on at the same time. She says she believes it's open court type proceeding with everybody being present. I don't think it's some of the lawyers are not particularly happy with that, some because of the too much conversation. But I think the more it proceeds in that fashion, everybody understands that they have to wait their turn. And Judge McClendon also has a DUI docket, and she's working on trying to do the same model that the criminal court judges are doing for their arraignments and for their bond proceedings and that sort of thing that criminal courts are doing. Eighth Circuit doing all his civil motions, Judge Jones, by teleconference or video, and he'll do it by video if everybody involved has the capability to do so, and they prefer that. But he also will do them by telephone, and he's available daily to hear specially set matters, emergency matters. I'm also available for that purpose, and I think Judge Jones is going to start hearing a few like damages hearings and things like that by telephone until we get an order that we can start doing non-jury trials and matters involving non-jury issues in the courtroom. So go ahead. I'm sorry.
Sorry, I was going to say, you mentioned that Judge McClendon's doing her hearings through a bridge line so that her court remains sort of electronically open.
Yes.
Have you had any issues, I guess, with other courts and some desire for the public to have access to hearings?
I haven't heard anybody mentioning they would like it to do it that way. I really think it's a lot easier because it takes more time to do it when you're doing it by telephone or video. When you're doing these motions by telephone or video, it just takes longer. And I think the more people that you have involved in the process all at the same time, the little more it allows for more confusion to occur. However, I think the longer that process goes, the easier it will be for people to adapt. And that's just what it comes down to, just adaptation to what we're having to deal with.
You mentioned jury trials. How many trials would you say have been continued because of the Supreme Court order, and what sort of backlog do you anticipate?
We have continued a good many cases. It's hard to know how many of those that are not have the T designation. In other words, the one that they're more complex. and have to be tried by that judge, because that judge, even though it's been assigned to that judge on the day of the complaint is filed, if there are not a lot of hearings, or any hearings for that matter, motion hearings or summary judgment, motion to dismiss failure to state a claim, or other matters, then they're easier to be heard by any judge. But if a particular judge hears many pretrial motions on that case, that judge should try that case. So I know several T cases in all the circuits have been continued. There's several others that I really don't know about. I mean, a lot of those that don't have a T designation, or a specific designation for a specific court to hear that case. Some of those cases get settled, and we just don't know. We just don't know about it. And I'm sure some of those have been settled. So I can't give you a real good number on backlog, because some of those cases likely have been settled, and I don't think anybody's kept up with those, and probably we should find that out. I'm sorry I didn't find that out before we had started this call.
Oh, that's okay. You talked a little bit about what would happen when we get back to having jury trials. What sorts of things have you been thinking about to continue to exercise social distancing, but be able to have jury trials throughout the rest of this year?
Well, and I've been, and I haven't floated this past my colleagues yet, although I've mentioned it in passing. But we can do civil jury trials with 6 jurors, and it would be a lot easier to conduct a 6-jury civil hearing and allow for social distancing to occur, because all of us have 14 juror chairs, and if we got 6 jurors, we can spread them out real easily among 14 chairs and have plenty of distance between those jurors. And it's fewer people in the venire, sitting in the back waiting to be called, if you're going to call it, if you're going to have a 6-person jury trial. So that's a remedy to allow things to move a little faster that I would suggest we might do. And the criminal courts can't do that. Each defendant has a constitutional right to a 12-person jury if they want one, and so there's not going to be any way to social distance. If you got 12 people in the jury box and 1 or 2 alternates, you got people sitting side by side, right next to each other, sneezing and coughing, so that's going to be more difficult, I think, to get going. But and it's going to be more difficult to get going if everybody insists on in the civil arena for a 12-person jury. But if you want to get your cases tried, I would suggest 6-person juries would be the way to do it, and keep social distancing as a very easy means of accomplishing that.
I know that you handle a lot of the pro se and sovereign citizen cases in Davidson County. How have these orders affected that docket?
Well, we've conducted so many evidentiary hearings on sovereign citizens who claim to be indigent. We've conducted indigency hearings, and I've had several of my colleagues volunteer to help. I've done several. I've asked my domestic relations colleagues, Judges Smith and Robinson, to conduct some of those. So the word's out. We're conducting those, and for the most part, we have found that these sovereigns who claim claim to be indigent and not able to pay the filing fee, for the most part, we found they have not been truthful. And so that word is out. So we have not really had many sovereigns in several years because of having adopted that process. Pro ses are always going to be around, and try to accommodate them. If they've got phone numbers, which they need to have, of course, and sometimes they don't, we can get them involved in conference calls just like we do lawyers, and we've been able to do that. So we're moving right along with them, just as we are with lawyers on motion hearings.
I want to take a brief pause just to remind everybody on this conference that if you have a question you'd like me to ask Judge Binkley, to use the chat function at the bottom of your screen to send a chat, and I'm trying to watch those and incorporate those questions in as we talk. Judge Binkley, what have you seen in terms of attorneys working together during this unusual time in our practices?
Well, I'll tell you this, I've found that, well, and I tend to have a little more of a relaxed atmosphere anyway, and I think trying to keep things light. If the judge is keeping it light, it kind of infectious for the lawyers. Not always, but try to keep things as light as possible, but still be adversarial, because it is an adversarial system, and that's the way it has to be conducted. But if everyone is doing their job and yet is being respectful with the others, the other attorneys, time to talk, and everybody has been so far, and I haven't had to try to keep order, because everybody understands this is unusual and unusual times, and we have to adapt, and adapting means maybe being a little more polite to your adversary than you would maybe in the courtroom. So I've found people are really trying hard to get to the end result, which means present your argument, do it in an adversarial fashion, but in a polite and orderly fashion, so you can get a ruling. And that's what people want. People want to get a ruling and keep moving, and I'm all for it.
Judge, I've got a question that came from our gallery. One
Yes.
question is, has there been any indication on how summonses are going to be served on new lawsuits or service of subpoenas by the sheriff's office?
I think I heard the sheriff is going to start serving at least the unlawful detainer warrants. I think I've heard that, and if he's going to serve unlawful detainer warrants, I'm thinking he might be trying to serve everything else. But private process servers or lawyers, can serve still, if you're willing to do it. So, as far as I know, that keeps on moving. I haven't heard anything to the contrary. I don't know what the lawyers' experiences have been. I know the sheriff has stopped serving process and hadn't really started back up, except I did hear that unlawful detainers he was going to start serving those. And I guess if he's serving those, he's serving everything else. But I don't know the answer to that. Sorry, wish I did.
Another question is, the Supreme Court issued a clarifying order on their COVID-19 orders, and suggested that pretrial orders and scheduling orders remain in place, but then talked about discovery deadlines still being in place. How is your court interpreting that clarifying order and the original orders in terms of case management orders and deadlines?
Well, I think it becomes case by case specific as to how things should be handled. I know that some cases that have been around a long time, I've got old case management orders that are really not maybe as current as they could be, and that's no criticism of anybody. It's just happens sometimes. And so I've been more lenient about that than I would have under circumstances other than what we've got now, and tried to let people have enough time to do what they need to do, even though if there's no real reason not to adhere to the scheduling order, then it should be adhered to. The scheduling order is out of date, and sometimes, and it's happened, particularly with cases been around a while, that the scheduling orders get out of date, and they've gotten out of date over the last couple of months because of what we're going through with this pandemic. So I've tried to be as lenient as possible and allow people to do what they need to do to get their cases prepared. But if there's no reason not to adhere to the scheduling order, then the scheduling order should be adhered to.
You mentioned earlier in this conference that you are having calls with 200 judges across the state. I'm interested in knowing a little bit more about how you're communicating with other judicial districts, and also what communications you're having regularly with the Tennessee Supreme Court.
I've not really had much. Well, I've listened to the when we have our weekly, and in fact we skipped a week, I think, but weekly meetings with Chief Justice Bivens and 200 plus judges across the state. I'll tell you, the primary issues that are brought up in those video conferences are criminal court issues. That grand jury meeting, grand juries are meeting. It's gotten got a pretty big backlog everywhere with no grand juries meeting and no indictments, on any of these new cases. So that's primarily what these conference calls have involved mostly criminal court matters. But I've had to get clarification on that minor settlement, $10,000 or greater with Chief Justice. I didn't think, the way I read it, the first order, that you could do those by teleconference or video conference, but he clarified that, said yes, that was what we anticipated in that first order. So that's the only issue I've had to contact Chief Justice about. But again, the primary focus on the teleconferencing with the judges across the state have been criminal matters.
I have another question from the gallery, and I'm going to read it word for word because I don't do real estate law. So if I try to ask this myself, I will botch it. The question is, closing attorneys are not accepting quitclaim deeds that are signed pursuant to Executive Order 26, which allows online notarizations. Banks are not wanting to face future litigation as they don't believe the governor has the power to do this. Mayor Cooper is now extending the stay-at-home order. What do you suggest that attorneys do to facilitate this function in the interim?
And I don't see that many real estate issues, but the issue is notarization of the signatures. And I guess the banks are not accepting declarations, right? I mean, I don't know.
Yeah, it sounds like the question is that whether or not there's going to be anything for attorneys to do in the meantime when certain people aren't abiding by the governor's order allowing online notarizations.
And you're talking about banks, I guess.
Yeah.
Is that the issue? Well, and I understand if they're afraid about future litigation, but I mean, if the order allows it to happen, I mean, I guess you you come to court and try to get it done, maybe through a court order. I mean, that's the only thing I can suggest. But I mean, that process has to keep moving too, and that the way to do it is how the governor has suggested. And I'm not sure. I mean, I get the lending institution being worried about future litigation, but we're all, everyone involved in business is worried about future litigation in some way. So this is just an unusual time, and if we've got a way to keep things moving, I think it ought to be used. It ought to be utilized. And if you have to come to court to make it happen, then that's what we're here for. That's my suggestion.
Judge, do you foresee any of the things that we're all doing right now to adapt to the lack of in-person court proceedings. Do you see any of those things continuing in the future, even after this pandemic has subsided?
Well, I, for one, I've been conducting a lot of things by telephone in the past, primarily for the convenience of lawyers. If we want to get things done, we can get it done quickly and more quickly by telephone, and particularly if the lawyers are out of county or out of state. Uh, and I foresee continuing to do that, and foresee if the lawyers are willing to do as many like that as we need to. But I don't think there's any substitute for being face to face in the courtroom. I really think that it's very effective for everyone to have face to face meetings when we're having argument on legal issues. But if we have to do it by telephone, if it's more convenient for everyone, if it saves time, saves money, I'm all for it. Continue to do it that way. I think my colleagues feel the same way.
I'm going to give one last opportunity to those in our gallery to ask a question of Judge Binkley that I'll read across to him, and then we'll close out this town hall session. So if anybody has a question, go ahead and pose it now, and I'll ask it to Judge Binkley. In the meantime, Judge Binkley, I've heard a lot of people trying to look at the silver linings in this challenging time. And so I wanted to ask you, what have you been most grateful for during this challenging time?
My good health, my family's good health. Very grateful that we're all very healthy. I'm in that age category, and even though I feel like I'm in very good shape for someone my age, I'm still in that category. So I'm very grateful that I'm still healthy, and I'm very grateful that I'm continuing to be able to come to the office every day and keep things moving. I really think that's really important for everyone, and lawyers need to keep the cash flow moving, and the only way to keep cash flow moving is keep cases moving. So I'm for it. I you know I don't like boredom, and if we don't have a lot to do, some degree of boredom sets in. So I'm I'm for getting back to normal, but I'm very grateful that I'm healthy, my family's healthy, and that I'm able to be in here to help keep cases moving as best we can with the restrictions that we have.
Thank you very much. And we're all grateful for your good health too, Judge Binkley. And we're grateful that you took the time today to talk to all of us about the procedures in Davidson County. And with that, I don't have any other questions, and I don't see any additional ones from the group. So we will go ahead and close out this town hall. And thank you again, Judge Binkley, for being with us today.
Pleasure is mine. Glad to always talk to lawyers. Fun. Y'all have a great day.
You too.
Thank you. Bye-bye.